Hello, I'm going to be talking about constructive evictions today. This is part of a video series offering complementary advice for landlords to avoid litigation and tenants to avoid eviction. Now, obviously, this is not legal advice specific to your specific instance. For that, you will need to speak to an attorney. Today's presentation will consist of 6 parts. It will be brief. It will be focused only on constructive evictions. We'll start with the bottom line up front of what is a constructive eviction, and then end with the conclusion. And please leave comments in the description and the comments below if you like this video and what topics you would like us to cover next. That helps us understand that people find these useful, and it guides us into deciding what videos to work on. So the bottom line up front is that in California, a landlord is expected to provide basic guarantees in relation to essential living requirements such as safety, habitability, and relief from harassment. So when a landlord fails to fulfill these responsibilities, the tenant might have no choice but to vacate the premises early and seek alternate accommodations. It'll be as if the landlord's behavior has forced the tenant to leave. Now, when this happens, the tenant has what's called an affirmative defense. And basically, the tenant would be subject to a type of eviction known as a wrongful eviction. So why would a tenant invoke a constructive eviction? Well, normally, a tenant should prefer to remain in their unit and fulfill their obligations under the lease. But when a landlord breaches their statutory obligations under the lease, the breach could be so egregious that the tenant has no choice but to find alternate accommodations that properly fulfill these obligations in order for the tenant to enjoy the health and safety benefits that these obligations were intended to provide. Now, a principle underlying the constructive eviction remedy is breach of contract. So when one party fails to meet their obligations under a contract, the breaching party should not expect to enjoy the full benefits of the contract, nor the harmed party to fulfill theirs. So when might a constructive eviction remedy be appropriate? Well, a constructive eviction might be an appropriate remedy where the landlord's breach was so egregious, such a material breach, that it substantially interfered with the tenant's beneficial use of the premises. So this interference could be through making the premises unfit for the purposes contemplated and or substantially affecting the tenant's enjoyment of a material part of the premises. Now, there's a standard that the courts will use called the reasonable person standard. And that's if the conditions in a tenant's unit have degraded so severely that no reasonable person could tolerate living at the unit any longer, then it's probable that the landlord has breached the implied warranty of habitability that applies to nearly all residential tenancies in California. And as a reminder, we're only talking about California tenancies, California law in these videos. So some examples of material breaches that might warrant the invocation of the constructive eviction remedy would be as follows. So breach of warranty of habitability. And in this case, the tenants likely would have a constructive eviction remedy whenever the landlord fails to repair and keep the premises suitable for the purposes for which they were leased. And the categories that fall within the scope of the implied warranty of habitability include weather protection, plumbing and gas, water, heating, electricity, clean and sanitary premises, trash facilities, floors, stairways, railings, working security devices, and lead hazards. What about a breach of quiet enjoyment? So there's also a warranty of quiet enjoyment that's implied, even if it's not expressed, in every California lease. And when I say lease, that also means any month-to-month tenancy. In this case, a landlord cannot interfere with the tenant's possession actively or constructively. And this is a warranty that's implied in the rental agreement if it's not expressed. And the breach of the implied covenant of good faith and fair dealing is another grounds that could justify the invocation of the constructive eviction remedy. Now, for the breach of the implied covenant of good faith and fair dealing, this holds that each party has an implied duty to refrain from doing anything that would deprive the other of the benefits of their agreement. Another possible avenue towards a constructive eviction remedy could be interference with the tenant's business. Now, this is usually only applicable to commercial leases, but if the tenant is operating a lawful business at the premises with the landlord's express permission, the tenant could raise the affirmative defense of constructive eviction if the landlord is substantially interfering with the tenant's business. What about reduction in services? This could be another option for the tenant to consider in deciding whether to bring a constructive eviction clause, and basically affirmative defense. So now affirmative defense means you're not denying that you did these things, you're affirming that you have a defense that excused your behavior. So if you didn't pay rent, you're not denying that you paid rent, rather you're affirming that you had a reason not to pay the rent. That's one of the benefits of being able to successfully bring a constructive eviction claim. So for the reduction in services, if the landlord reduces or terminates important services that substantially affect the tenant's beneficial enjoyment of the premises, this could result in a constructive eviction, as well as bad faith conduct by the landlord. So a constructive eviction might result where the tenant is forced to vacate pursuant to service of a notice to quit in bad faith or with malice from the landlord, such as when there's no reasonable belief that the tenant has breached the lease, but the landlord is acting petty or with malice to basically make it so unbearable for the tenant that the tenant has no choice but to leave. Now, this may also afford a tenant a damages remedy for wrongful eviction. Next, failure to deliver possession. So this would be where the rented premises were never actually delivered to the new tenant, and this could give the tenant a right to abandon the tenancy and sue for damages. This also terminates the tenant's ability or liability for rent. So normally delivery of possession is complete where the premises and keys are delivered to the tenant, unless there are existing occupants in the unit. And failure to deliver possession might also enable recovery of lost profits by the tenant under a theory of breach. So how to invoke the constructive eviction remedy? Well, first, you need to notify the landlord. Don't keep this a secret of what the issues are. The tenant should notify the landlord and provide the landlord a reasonable amount of time to redress the issues that are or should be within the landlord's ability to redress. The tenant should make all requests in writing, and this is always important. It can be a text message, an email. Email is great. Text messages are not so great. They're harder to share if there's a hearing. Email is very easy to authenticate because you basically have almost two-factor authentication. If the sender doesn't want to provide the email, then the recipient can have the record. They can also be subpoenaed. So, same with text messages, but those are more difficult in my experience. If you have a written agreement, that's fine. Of course, that's fine, a written contract, but that's not always practical when there's frequent communications. You're not going to be sending a letter as often as you'd be sending an email or a text message. And include photos if you can. Email is great for photos. The resolution is going to be higher. It's easier to search the emails. It's easier to keep things organized and archive them. So preserve all written communication records, and don't ever record your landlord visually or audibly without your landlord's consent in California. So after the landlord has had proper notification and time to redress the issue or issues, the next step is for the tenant to decide whether there are any other options but to break the lease and move out early. Next, the tenant should seek to find accommodations that are reasonably similar in price and location to the originally leased premises. And the tenant must completely vacate the premises in order to raise a credible constructive eviction claim within a reasonable time after the landlord's material interference with the lease. Now, as a tenant, you must never cause undue damages to the premises, including during your move out. You as a tenant can still be held financially responsible for any damages and costs that are rightfully attributable to you or the parties in your tenancy, such as your spouse, any parents, in-laws that are living there, and especially your kids. And then upon complete move out, the tenant's financial and contractual obligations will terminate unless the tenant moves back in. So if you, the tenant, move back in, then all of your previous obligations, such as for the rent, will resume. And you, the tenant, must keep records of all expenses associated with moving out and finding alternate accommodations. Now, some or all of these expenses could be sought as general and or special damages to be reimbursed to the tenant by the landlord at a later date. These expenses may also rebut the landlord's claim for unpaid rent accruing after the date of the constructive eviction. And lastly, the tenant could move out and bring a suit against the landlord for the consequential damages arising from being constructively evicted, or you, the tenant, could wait for the landlord to bring a civil suit for unpaid rent and raise one of the breaches that I mentioned earlier as an affirmative defense to the landlord's claim for unpaid rent which accrued after the date of the constructive eviction. Now, if you found this helpful, please let me know in the comments. Your feedback helps me understand what people are finding helpful and what they would find to be helpful, and I will make more videos if I get enough feedback. Thank you for your time, and I hope you found this helpful.